Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at family law, an area which I practice in and an area which I'm fascinated to see is changing quite dramatically at the moment. And we've got this book which has come from Jordan's. There'll be a lot of them coming. This is the family law imprint from Jordan's. It's called Reforming Family Justice. It's got other titles in other parts of the world, but what it is, it's a guide to the Family Court and the Children and Families Act 2014, and it's been written by two people, Sarah Blackmore and Jacqui Thomas. Now there's a foreword by Sir James Munby and there's a preface by Lord Justice Ryder. What we've got with this book, and I'll just show it to you now, is a paperback of 500 pages. There's not that much in the way of an index, as you can see, but what you have got is a very great deal of detail about what has happened and what the changes are in the system. Let me open the book up. You see you've got some paragraph numbering at the sides, you've got footnotes, the usual stuff is there. The various chapter headings are done. There are some useful forms that are included as well as to where we're going at the moment with the system itself. And I'm just looking to see, here we go, the start of one chapter, chapter 5, dealing with expert witnesses. You see there, you start with the need for reform, then paragraph numberings, the changing culture, and then all the other various things that are happening, robust case management, for instance. Now at the front of the book you've got the standard front heading, then you've got a foreword by Sir James Munby, and then you've got a preface by Ryder, Lord Justice Ryder. Then you've got an introduction which sets out what's been going on, because anybody who's involved in this needs to know what the changes are. It's only a short introduction, do read it, acknowledgements, and then you go straight into the contents. Reason why we've had to change the system, anybody involved with it will know why. Then you've got the various chapter headings, and you've got then quite a large number of appendices. And then from that, of course, you lead into cases and statutes, and then straight into chapter 1, the case for change, and the family justice review. Now, I'm not going to say too much about the review because this book is really here to help us as practitioners and everybody else about what has really been going on. Now, let me explain what we say in our review of this work. We've given it the title, Clear Guidance and Authoritative Comment on the new Single Family Court and the Children and Families Act 2014. And this is what we say. My wife Elizabeth and I discussed this book. She's aware of what I do. She's my Chambers Administrator, so she knows the sort of problems we've been having. And we came up with this review. We say this latest title from Family Law imprint of Jordan's publishing is referred to by Sir James Munby, President of the Family Division, as, quote, a large and important book that should be on the shelf of every family lawyer, and he's absolutely right. The basic reasons as to why are explained in the book's succinct and informative introduction by co-authors Sarah Blackmore and Jacqui Thomas, and they remind us the family justice system in England and Wales underwent seismic change in 2014 when the three-tier court system of Family Proceedings Courts, County Courts and High Court was replaced by the Single Family Court, which I'm now practicing in. I'm recording this in November 2014. The Crime and Courts Act 2013 and the Children and Families Act 2014, that's the 2014 Act, as I'm going to call it, are the two key pieces of legislation which engineered this change. The aim of the book, therefore, is to provide family practitioners with an overview of the 2014 Act itself, to explain the reasons behind the reforms and to provide up-to-date case commentaries. It's logically organised, and it begins with a historic perspective in chapter 1, followed by 6 chapters which cover in all relevant detail a range of issues from, for example, the aims of the 2014 Act through to dispute resolution services, adoption reform and the new ethos in forming transparency and reporting restriction orders. The three main areas affected are public law, dispute resolution and private law. Private law, as we're also reminded, is the area which has given rise to the new Child Arrangements Programme, CAP, which aims to simplify court proceedings and processes, including contact and residence matters, to cite only a couple of examples. Obviously, I'm going to be using terms which we are probably more familiar with, but we are again going through this period where we're going to be using different words to describe what perhaps we know, but I call them contact orders still, but obviously we will get slightly different words and abbreviations coming in. It's complex and sensitive, of course, as far as these areas of law are and remain. So the focus generated is largely by the reforms, which is more, in fact, markedly child-centred than it's ever been before as a result of what we've seen with the legislation. So, quote, "No one involved in family justice," say the authors, "should be in any doubt that the child welfare should be their paramount concern." And that's, of course, the basis of the Children Act itself. The book evolved as a result of the research undertaken by the authors whilst compiling family law updates on a weekly basis. And James Munby, or Justice Ryder, and other experts also provided their input of support and advice for the final version. Endowed with the voice of authority, the book functions not only as an unassailably accurate practitioner's guide, but as a helpful assistant to litigants in person seeking to understand the system and the impact of the changes brought about by the new legislation. And I would say here, because so many litigants in person are no longer able to get legal aid, that's why they're in person, they do need to know about this book and know what's happening. Let me conclude by just saying that practitioners eager to familiarise themselves with the structure of the family court and the resulting arrangements will find this book invaluable, as will anyone involved in family law proceedings. And that means people who are advisors as well as practitioners. The publication date is cited at the 30th of June 2014, and it's come to us obviously later in the day. That's the book again, and there's the commentary, the short commentary on the back. I'm sure we're going to get more about this as time goes on, but you can see, for instance, chapter 4 deals with public law, just to show you again that it's logically structured as to looking at the particular areas that you in practice may be finding impacts on your actual practice itself. So I do think it's worth reading, and do have a good look at it. Also, you've got quite a useful amount of detail in the appendix at the back. For instance, this is on financial remedy orders, the old ancillary relief as we used to call it, and so on. But you've also got the rules that have come in, the statutory instruments that have come in as well. So all in all, it's a detailed book, but it's a very good one. I'd like to thank the authors and all the people who've been involved in this, including Jordan's Family Law. It's the sort of thing we do need. Jordans really are leaders in this field because they produce some excellent stuff, and their conferences are well worth attending as well. So thank you very much to all concerned, and do have a look at our review, which is on the web and in the journals. Bye bye.